Ms. Romanos, can you hear me?
Yes, ma'am.
All right.
He's on break, so he doesn't have his qualifies. You can come out, and I'll have him from the board.
All right, so are you Myrta Romanos?
So,
Yes, ma'am.
Are you the same person who in 2024 CR 4074C was charged with the offense of tampering with evidence with intent to impair a human corpse? And in 2024 CR 4076 with tampering with evidence, and in 2024 CR 4075C with abuse of corpse. Is that you now?
Yes, ma'am.
All right, now your attorney has filed motions in each one of these cases to reduce your bonds. So, counsel, it's my understanding before we start, on 4074C, the bond is now set at $300,000. You're seeking to reduce the bond to $250,000. In 4075C, the abuse of corpse, the bond is set at $100,000. You're seeking to reduce that bond to $75,000. And 4076, the tampering with evidence, you're seeking to reduce the bond from $200,000 to $125,000. Am I stating that correctly?
Yes, Judge.
All right, go ahead, please.
For the purposes of this hearing, I'll call Ms. Romanos.
Oh, you're calling Ms. Romanos?
Yes.
Sorry, Ms. Romanos. If you can hear me, ma'am, can you hear me?
Yes, ma'am.
Okay, raise your right hand for me, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Now, is she just that much of the screen that I'm seeing, or can you see more for there?
No, I can just see a
put
little,
your, yeah, you can put your hand down,
it's
Mr.
an
Romanos.
iPhone picture.
Yeah, it's very small. All right. Oh, Ms. Romanos, I know that you're on a Zoom screen, so can you lean back a little bit so we can see your face? There you go. There you go. Can you still hear me?
Yes, ma'am.
All right, so we can see your face if you stay the way you are right now, but before we couldn't really see your entire face. So go ahead, Mr. Bond.
Thank you. Ms. Romanos, you're the same Myrta Romanos that is charged in these three offenses, is that correct?
Yes.
And just for this court's knowledge, this is the second time we've come before a court seeking these bond reductions, is that correct?
Yes, sir.
And we had a prior hearing back in February of 2024, is that correct?
Yes.
Okay.
Understand.
Now, regarding
I can't see
these particular bonds, you have tried to
Make yourself clear.
Okay, hang on.
yeah, I'm sorry. I didn't,
It's not your fault. I think they're trying to assist us being able to see her better because the screen is going very fuzzy off and on. Right, we were at the second time seeking a bond reduction before a court. The last time was February 2024. Next question.
Ms. Romanos, have you tried to raise the money needed to make the bonds as they are currently set?
Yes, sir, but I have not been successful.
Okay. And just like in the last hearing, I'll ask you these questions. Do you have any bank accounts?
I don't think so.
Okay. Do you currently own any real property?
I do not.
Do you own any automobiles?
Supposedly I have one, but it's in evidence.
Okay. Any stock accounts, any savings accounts?
No,
Okay.
nothing.
How long have you been incarcerated?
16 months since January 11th of last year.
January 11th of 2024?
Yes, sir.
And you've been in continuous custody since then, correct?
Yes, sir.
Okay. And you understand that we're here today asking this honorable court once again to consider reductions on these three charges, correct?
Yes, sir.
And the bonds that are set, they're the same bonds that were originally set at the time of your arrest, is that correct?
No, sir.
They
The
were,
original,
I'm sorry, go ahead.
was 1.1 million.
Right, so They have been altered somewhat, but still not to, they have not been reduced to an amount that you can bond out, right?
Correct.
Okay. And the charges, you know you have 3 different charges where you are facing, correct?
Yes, sir.
Okay. You understand that when the court considers bond reductions, there's certain things the court has to consider, and some of those things are the safety of the community and the ability to guarantee that you're going to show up to court, correct?
Yes, sir.
And one of the opportunities and one of the things the court can do to guarantee that is to place you on global positioning satellite. Are you familiar with GPS?
Yes, sir.
And GPS has a requirement that you have an address that you can go live at. If you were to be released, or at some point, if you were to have a bond reduction and make a bond, do you have an address here in Bexar County? And I'm not asking you to tell me that address by any means, but is there an address in Bexar County and someone at that address where you can go live with?
Yes, sir.
Okay. That's all I have, Judge.
If I may, Judge.
Yes, please.
Ms. Romanos, I think one of the first questions Mr. Bunk asked you was that this was the second time you've come before a court for a bond hearing, correct?
Yes, sir.
This is actually the third time though, right?
Yes, sir, in person and then in Zoom, sorry.
We had one bond reduction back in February of '24, which I think is the one he's referring to, in front of Judge Nahara, which I believe that one you were in person, and your bonds were lowered on that at that time, correct?
Yes, sir.
And then we had another one back in December of last year where you appeared on Zoom, correct?
Yes, sir.
And the bond motion was denied at that time, correct?
Yes, sir.
At that bond hearing back in December, we did talk to you about some of your assets at that time, and we did ask you about a house on Charlie Chan that you said you had some ownership in. Do you recall that?
Yes, sir.
That house has now been sold, correct?
As far as I know, yes.
You did have some ownership in that house, correct?
Yes.
Where is the money from that sale that is your portion of the sale of the address on Charlie Chan?
Excuse me, can you repeat that again, sir?
So if the house sold and part of it was yours, you do have some money from the sale of that house, correct?
Yes, sir.
Do you know how much that is?
I do not, sir.
Have you asked people who you speak to find out how much money was yours from the sale of that house?
No, and I haven't been told any amount at all.
So you haven't asked and you haven't been told.
No, sir.
But you are trying to get out on bond. Wouldn't that be important for you to know how much money you have, and if you have money from that sale of that house where you have ownership in it?
Yes, it would be.
In addition, when we had the bond hearing back in December, we talked to you about some things that were inside that house that were left behind when you, your son, and Ramon were arrested. And I believe you mentioned that you guys had pawned some of the stuff that was in there, but there was a lot of furniture and other things that were still there, correct?
As far as I know of, there was, I haven't spoken to my son. I don't know what he did with it. So I have nothing that I know of, to be quite honest. I have what I came to jail with.
Have you reached out to anyone to see if any of the property, including jewelry and furniture that was inside the house, could be sold in order to help you make the bond?
In the beginning, I did. I tried contacting my son, and he's just not answering my calls.
You mentioned that your bond, I believe either you or your attorney mentioned that your bond is a total of $600,000. Have you had conversations with a bond company to find out how much you would have to pay to get out?
No, not personally. I'm in lockdown, I'm 1 hour a day. It's hard to shower and make phone calls and make sure my area is clean and do other things that I need to do.
Understood. But have you reached out to maybe anyone who you're speaking to get them to try to find out how much money you would have to put down to make the bonds as they currently are?
They're supposed to be finding out for me, but they haven't told me anything yet.
Defense counsels mentioned that if you were able to get out on bond, that you would be able to perhaps be on GPS home arrest, correct?
Yes, sir.
And you mentioned that you would be staying at an address in Bexar County somewhere, correct?
Yes, sir.
Would you be staying at that address with your husband, Ramon Preciado, who's a co-defendant in this case?
Yes, sir.
So the address you would plan on going to, your co-defendant and your husband would also be living at that address?
Yes, sir.
Ms. Romanos, what type of employment did you have at the time that you went into custody for this offense?
At the time, I helped my husband with his HVAC business, making phone calls, making schedules, helping with the equipment, things like that.
Is that a position that you are still able to go to if you are out on bond? Are you still able to help your husband with his AC company if you were on bond and on house arrest?
To be quite honest, that I'm hoping that I can. I would know until I'm actually put in that situation that I can be out and be able to do that.
I guess what I'm asking is the job that you had when you went into jail, is that job even a reality at this point? Does your husband still have the ability to have an AC business that you could work and have employment there?
To be quite honest, I'm not sure, sir.
I'll pass the witness, Your Honor.
Mr. Bond?
Thank you, Judge. Ms. Preciado, Ms. Romanos, we talked about,
Yes, sir.
I'm sorry. The bonds that are set, they've been set since December of 2024, and I know that back then, there were discussions about, with other members of family and friends about trying to raise that money, and that money was not able to be raised at that time. And as I understand it, you have no idea what happened to the funds from the sale of the house, is that correct?
That's correct, sir.
And as far as getting out of being able to work, I've indicated, is it your understanding that you very well might not be allowed to do anything other than get out of the jail if you make bond, go home and wherever that home is, go somewhere and just be forced to stay there under house arrest and not leave that address, is that correct?
That's
Right.
starting to be my understanding, yes, sir.
Ma'am. And I've also indicated to you it's possible that you might not be allowed to have contact with your co-defendant if released. You remember that discussion as well?
Now, can you refresh my memory on that,
Yeah,
please?
You may have to have an address not living with the court may order that you not be allowed to be around your co-defendant as a condition of your bond. Do you remember when we discussed that as well? You may have to have another in other words, you may have to have another address.
Okay.
Okay.
I didn't.
Okay. And how long has it been since you said you've lost you haven't spoken to your son? He was the one in charge of the contents of the house. Am I understanding that correctly?
Yes, sir.
Okay. That's all I have, Judge.
Nothing from the state, Your Honor.
All right. Do you have any other?
No more
witnesses?
evidence, Judge.
All right. So you're resting on evidence?
Yes, Judge.
State?
Yes, Judge. The state would offer a couple of exhibits to the court. Judge, the first exhibit we have is State's Exhibit 1, which is a copy of the prosecution guide from this case. Judge, I will say it's 171 pages long, but I'll offer that to the court for their review. I've previously tendered that to defense counsel for any objection.
Objection?
None, Judge, for the purpose of this hearing.
Additionally, Judge, I have State's Exhibits 2 and 3. And while we're offering all of them, I'll offer also 3 and 4.
You already said 2 and 3.
You said
so-
2 and 3.
I'm sorry,
So you got
4 and 5.
4 and 5. Okay.
And I have also previously tendered those to defense counsel. State's Exhibit 2 and 3 are photos from the scene involved in the case where the bodies are recovered.
Objections?
None, Judge.
Admitted.
And Judge, I also have State's Exhibits 4 and 5, which are surveillance videos. State's Exhibit 4 is a surveillance video from the house where Ms. Romanos lived at the time. And State's Exhibit 5 is apartment surveillance from the area where the bodies were found. I may allow the court to look at the prosecution guide. After that, I can show you these. They'll become more.
I think that will make more sense, but you're moving to admit them at this point, so 4 and 5
No objection.
admitted. All right. Do you have more that you're gonna admit?
That's it, Judge. Those are the things that I'm going to admit for
Give
purpose.
me some time.
Yes, Judge.
Your Honor, pardon the interruption, is that a better view?
That is a very good view, thank you.
Thank you.
gun that was it 38, the gun that was recovered from the defendant's house, was that or was that not the murder weapon?
It was, Judge.
It was
It did
murder.
match the ballistics.
Okay. And then, is there a part of this, because it says 150 pages, and I'm a quick reader, but I'm not that quick, is there a part of this where, because the statement made by, Mr. Preciado and the statement made by the defendant, neither one of the statements nor Christopher Preciado's statement puts this defendant at the scene? Is there a part of the prosecution guide you can point me to where it actually places the defendant at the scene?
So Judge, if you go to page 42,
That's what I'm
that's
asking.
where it summarizes the videos, which are what places Myrta there. 42 through approximately 55 are,
Thank you.
yes, Judge.
gonna show me those surveillance videos?
Yes, Judge,
It's here.
in addition, Judge, if I may, I do have, we can do this one of two ways. Judge, I know statutorily you do need to see her criminal history. I do have a TCI NCIC that I can conditionally admit to be withdrawn at the end of trial, or at the end of this hearing.
Yeah, we've already done that today, so we can do that if you
Sure.
wanna do it that way.
The only thing though, Judge, is, she only has one charge, and, I think she has one charge from 1994, and it's not super, completely reflected on the TCI NCIC. It only shows as an arrest. I can supplement with the fact that, it was just that singular, arrest back in 1994 for shoplifting. She did 6 months of deferred on that. She had an MTR, but it was then withdrawn and she completed it successfully.
Okay.
With that being said, I'd offer State's Exhibit 6, which is just gonna show the arrest.
A conditional offer to be withdrawn, later admitted. Or do you have anything else?
That's it, Judge. I think just based on the age of it, for whatever reason, it's just not.
Yeah, probably. Probably. There you go.
And if I can, I'll show you the surveillance video.
Yes, if you would.
Two clips on this disc, Judge. The first is. It happens quickly in this video, but you will see what we're alleging is a towel being handed outside. That's the blood. State's Exhibit 4 is the Charlie Chin residence. It's owned by the defendant.
So I was looking at 5 before.
Correct, yes.
Yeah.
This is 4. And it shows them returning to the residence after going to the in front. Broke down. That's the way. did offer the photos, which
Yes.
have been.
Review. All right. Anything else?
Nothing further from the state, right?
Was there just one interview with each one of the defendants?
There was only one interview with Myrta specifically. There was only one interview with each one of them.
So this is just a repeat?
Correct.
Box guy?
Yes,
Okay.
Judge.
All right. Argument? I'm
I'll-
assuming you're finished with your evidence.
Yes,
correct?
Judge, state
Okay.
rest.
I'll waive opening and reserve right to close.
Go ahead, please.
Would you like me to stand up, or am I?
Oh, you're fine.
Okay. Judge, if I may, Judge, the thing that the state would say, number one is the facts of this case. Obviously, that goes into this decision. This is an incredibly egregious case. We have a murder of not only 2 individuals, but one of them was pregnant with a child that was about to be born within 24 hours of when this murder happened. The fact before the court, the son of the defendant committed those murders in front of their house, and this defendant assisted in the cover-up of that in terms of going over to this apartment complex, helping and assisting both her son, who committed the capital murder and is charged with capital murder, and her husband, who's also charged with the tampering and cover-up that she has of the cases.
So he's charged with the same 3 offenses that she's charged with?
He is, Judge. The only difference is he has 1 less count because she's charged with a gun and not him. So he has 1 less charge in that regard. While the whole community and the family of Savannah Soto and Matthew Guetta are looking for them because baby Fabian is supposed to be born at any minute, these 3 defendants obviously are taking part in this murder, and then the other 2 in this cover-up. Judge, the facts of this case are incredibly egregious. I think that's something that, for the court's perspective, Ms. Romanos is facing a lengthy prison time based on the facts of this case. I think that causes an even greater ability for her to be a flight risk based on the charges that she's facing, the fact that the facts are so egregious. In addition to that, Judge, this case is, the actual type of case is the charge is an assault on the legal system. Essentially, she is trying to cover up an offense, that is going to come before the court, and the very nature of the type of offense she has is a deceitful one. Regarding her ability to make bail, Judge, our argument would be that she has not carried the defendant's burden to show that the bail is excessive. I think in our cross-examination of her, I think she's shown that she's not shown what assets she does have, and that she's even exhausted her means on those assets. Multiple times she said she hadn't asked about the proceeds of the house, which she said do belong to her. In addition, even the amount that she would have to make to pay for the bond, she's unsure of those things. I don't think she's carried her burden to show what assets she has, what amount of methods she's taken to acquire these funds, and therefore we think that she has not carried her burden to demonstrate that the bail is excessive in that regard. Finally, Judge, one of the things that I think is especially concerning for the court also is that for her to be on bond, she's planning on residing with a co-defendant on this case. They conspired together to commit the cover-up of this, and the house that she claims she would be going to, she says that Ramon Preciado is there, and she would plan on residing with that co-defendant who is out on bond at this time.
So he's not in jail?
No, he's on bond. He made bond, I don't have the exact date, but approximately a month and a half ago, maybe.
Okay, and Christopher Preciado?
He is in jail.
He is
Her
in
son is in jail. However, the place she is saying that she would go out, and the stable place that she's saying she would go out, is the place where her co-defendant in this case resides also. In addition, I think that she also laid out that her employment isn't something that she has as secure anymore. If she were to be out on bond, having to make appointments, having to have a GPS monitor, I don't think she has shown the stability that she's able to do those things. Judge, I do have some case law. The first case I do have is Ex parte Alfredo Castillo Lorente. It's 420 Southwest 3rd 884, and I'll give a copy to the court. In addition, I have Esquivel v. State, 922 Southwest 2D 601.
922, I'm sorry.
Sorry,
You're gonna
Judge.
give it to me though, right?
Yeah, I'm gonna give it to you.
Okay.
It's 922 SW 2D 601 for Esquivel. I'm giving you a copy of both. And I'll call the court's attention on Esquivel. I'm sorry, on the first one, Castillo Lorente. There's several things in this case that I think are appropriate. Obviously, some of these things the court already knows. But, you know, it talks about the defendant carrying the burden to prove that the bail is excessive and to demonstrate that the inability to make bond, they must establish that his and his family's funds have been exhausted. I think in this particular case, Ms. Romanos has not been able to do that. In addition, this one also talks about that when the offense is serious and involves aggravating factors, that may result in a lengthy prison sentence. The bail must be set sufficiently to secure their presence at trial. The final thing in this particular case is also what we have in Esquivel v. Texas. It's just that talks about the accused's ability to make the bond is only one factor for the court to consider, and it's not dispositive. The court can take into consideration, obviously, all these other things, and that is not a dispositive factor for the court, especially in a case like this where the facts are so extremely egregious. For that reason, Judge, we would ask you to deny the bond reductions against Mr. Romanos and to leave them where they are.
Mr. Vaughn?
On behalf of Ms. Romanos, she testified that when these bonds were set at the amounts they're set at, back in December of 2024, she and her family and friends tried to raise those amounts and were unable to. So the fact that she, as of right now, has been able to check currently whether she can, she can't. She doesn't know. She has no idea what money she has anymore. She can't contact anybody. She's in a jail cell 23 of the 24 hours a day thanks to the bonds that are set and are oppressive. One of the factors they keep referring to is this excessive prison sentence she faces. There are 2 third-degree felonies and a state jail felony. That's what she faces.
A second degree and a third degree.
That's correct, Judge.
And a state jail.
Correct.
A second, a third, and a state jail.
That's correct, Judge.
I looked it up, Mr. Funk.
Okay.
Just to make sure. And the tampering with the corpse is second degree.
2 second, okay, second, the third, and the state jail.
Mm-hmm.
Now, the oppressiveness of the bond, we know that she has the ties to the community. We know that they talk about flight risk. She was arrested in her house. So she didn't flee. She was there. She was still there in her house when she was arrested.
On Charlie Chan.
Yes.
So we are absolutely, the same house from which she was arrested, we absolutely know that that is her house and that house has been sold, correct?
As far as she knows, she doesn't know what's happened to the house. She doesn't know what's happened to the
I
house.
think she said it was sold.
She believes it has been sold.
Mm-hmm.
Correct. Now, so we're asking, and if you look at the cases, 4076, the bond is $200,000. We're asking not for a sizable reduction. We're asking from 200 to 125. We certainly think that's appropriate. Now, the $300,000 bond in 4074C, we're asking from 300 to 250. Once again, we don't think that's out of line with that offense. And the state jail felony, it's $100,000. We're only asking to be reduced to $75,000. Once again, we don't believe that's out of line with what's going on. So what you have is someone who's been in jail now for 16 months, still doesn't have a trial date.
Why not?
That's a great question, Judge, and we would all like to know that. One of the delays was the state couldn't make up their mind on this death penalty issue. So we were behind. We waited and we waited and we waited. And April the 4th, they finally made up their mind.
Okay, but she couldn't have been charged with the death
No, she couldn't have been, but they wouldn't let us proceed until they made up their mind on the death penalty, on the other count.
I'll let you respond. Hold on.
So April the 4th, that decision was made.
April the 4th of what year?
Of this year. The offense was January of the last year.
Okay, no, I
So
know.
she's been waiting and waiting and waiting. in jail, and at some point, when the bond's not reduced, the bond simply becomes a tool to ensure that she remains incarcerated. She cannot make this bond, or she would have. So certainly the fact that she's still here is indicative of the fact that the bond is oppressive. There's no evidence she's a flight risk. You didn't hear any evidence of flight risk. I mean, there's no evidence that she has of her criminal history. She had a shoplifting deferred from, I forgot how long.
94.
I thought
1994.
40, 30 years ago. So the things you have to look at, the nature of the crime, of course.
Mm-hmm.
And I understand that. I'm not denying that. But then you look at the amounts of the bond, in consideration for what she's charged with. Second, third, state jail. So these bonds of 200, 300, and 100. So we are asking for the reductions of 200 to 125, 300 to 250, and 100 to 75. Now, certainly the court can not allow her to live with the co-defendant. And that's the court's, absolutely at the court's discretion. And if that's what the court says, then that's what she'll do. I mean, if the court, a no contact order is certainly something the court can order, and she will abide by it. And if there's issues with her affording a monitor or abiding, that's something she'll have to deal with. But for them to say, well, she says that's where she's going to live. Well, of course that's not where she's going to live if the court says that's not where you're going to live. So I mean, they're kind of putting the cart before the horse, and they're saying, well, that's where she's going to go live. Well, she's not. If you say that's where, and I anticipate that that's not where I don't think that's where the court's going to let her live. So that's a non-issue. And if she can't find another place to live, well, then you know what? Then she's not getting out. And then that's on her. So, but once again.
What really bothers me, Mr. Bond? And I know you said, well, she doesn't know the house was sold. She definitively testified it was. And hold on.
Yes.
Let me just state why I have an issue with this. Because if this was a house that she had an interest in, then she would have been involved, even if they had to take paperwork over to the jail for her to sign it, she would have been involved in the sale of the house. Otherwise, it could not have legally been sold. In which case, she should have had some type of information about the sale of that house. And she definitively testified that she believes that it was sold.
Correct.
And so, we're all lawyers. We know you can't sell somebody else's property without their approval and without them being involved in that sale, which makes me feel like her knowing nothing about what interest that she could have received from the sale of that property, it makes it feel disingenuous. And then I'm assuming, because nobody ever told me, but now I'm assuming that there's another son out there who had control over property inside the house. Couldn't have been Christopher Preciado because he's in custody. Has he been in custody since day one?
Yes.
Okay, so there's another son out there. And that son apparently had control over the contents of the house. But then you have Ramon Preciado out there on bond.
Correct.
I'm having to assume that would have been the other owner of the house. Maybe I'm wrong. But so we don't know about this amount of money or the sale of this house. And I find it very hard to believe that a sale of a house that she has interest in could have occurred without her participation somehow. And I'm just kind of up in the air about that, because that means that there is, by the way, if it's not sold, that means there's also real property. Real property that could be sold.
Correct.
To be able to afford these bonds. See what I'm saying? So
I-
either over here or over here, the property sold or the property not sold, then the court has an issue as to whether or not there are funds available or assets available, and that's not clear.
And she doesn't know the answer to that. She truly doesn't know what's going on with that. She doesn't know. In my talk, my understanding is she answered truthfully. She doesn't know what happened to the house, And she answered, when she told the court she doesn't, that's her, I'll inquire further if the court would like.
Well, okay, but see, the thing is she's already testified that
Right.
it was sold,
She
okay?
believes, she said she believes it was sold, yes.
Right, and if it's her property, it couldn't have been sold without her consent or her participation.
Yes.
I mean, you know, we're lawyers, you can't
Yes.
ignore the law,
Correct.
that's the way it goes, yep, okay.
Well, I understand the court's position.
Yep.
But she's, even if the house had, assuming the house had been sold and she had access to money, she has not been able to make the bonds as they are currently set.
But that's not what she said.
Well,
That's really not what she said. She didn't say, oh, I got this much money from the sale of the house,
she,
and I can't cover the bonds with that much money. That's not what the court heard. That's not an evidence.
her evidence was she hasn't received any, to her knowledge, she hasn't received any money from the sale of the house. Was what,
Okay,
her having said that, she's not been able to make the bonds. She hasn't been able to raise the money to make the bonds. She's not able to contact anyone in her current status at the jail. So for those reasons, I'm asking the court, we're arguing that the bonds as they are currently set, they are oppressive. They're not reasonable. There's no evidence she's a flat risk. There's no evidence that she won't come to court. Her criminal history is minimal at best. For a second and a third and a state jail felony, I don't believe these bonds are appropriate. We're asking to be reduced from 200 to 125, from 300 to only 250, and from 100 to only 75. Once again, I don't think these are what I don't think it's a big ask. In other words, I'm not asking for 200 to 75 or 200 to 50. I'm asking for only 200 to 125, 300 to 250, and 100 to 75. Which I think for the offenses, those reductions, in my mind, consider the gravity of the case. In other words, when I chose those amounts, I considered what the court has before it in the prosecution guide. So I did not choose those amounts without consideration. So on behalf of my client, Ms. Romanos, that's what we're asking the court to consider. Thank you.
I know I said I'd give you a chance to respond. Go ahead.
Honestly, just briefly on one issue, I think it's just on the issue of the proceeds of the house. Her testimony was that the house had been sold, and then I did ask her, have you asked about your proceeds of things, and she said she has not asked. She also said she hadn't asked about the bond. The issue that I have, that the argument that's being made now is that she doesn't have the ability to ask, yet she's lined up somewhere to stay on the outside. She has the ability to ask about these things. Furthermore,
And she's lined up, I'll make note, she's lined up that she would be staying with Ramon Preciado.
correct, Judge.
Yeah, I got it, I know.
In addition, Judge, the house actually, the proceeds, our understanding and what she has testified before is the house is from her father, so it goes to her. She is the direct beneficiary of that, and whatever interest was in it was not even going to Ramon Preciado, it was going to her. So I agree with the court that at this point, the house has been sold, which she has some type of interest in it, or if it hasn't been sold, then she owns part of a house. And those are assets which can be considered by the court. I just feel like she hasn't demonstrated what assets she had and that she's exhausted those in an attempt to make the current bond.
All right, well, Mr. Bunk, you have the final say-so, because these are your motions.
That's all I have, Judge.
Okay. I'm gonna deny the motions. Did I hand you guys your criminal history?
Oh, we didn't, Judge, if I could do that on the
Yeah,
record.
let's do that, because, are you sure I didn't?
It's right here, Judge, I'm sorry, I see it up here.
Okay, I was gonna say, I don't have it, so I just assumed that I'd done that.
Just for the record, State would ask to withdraw State's Exhibit number 6, which is a TCIN pursuant to the law for disclosures that we would ask for it to be withdrawn for purposes of this hearing.
Granted.
Oh.
Yeah.
Thank you, Judge. Yeah.
afternoon, Judge.
Good afternoon. Haven't had a break since I took the bench, so what are we
No,
doing?
no, no. Judge, this is on an Eggert, that I gave to Monica earlier. She's incarcerated, out of this court, out of a judge's warrant out of this court, and she didn't appear for her mental health, she appeared for some consideration, but she didn't appear for the hearing on it.
Where is she?
She's in jail right now, but she is, it was set one day, it was assault for the next day, Mr. Rodriguez issued the warrant. I mean, last time I brought her here, I personally called an Uber to bring her down. Well, she'll be here, Judge, I just need to get her out.
She have all these cases or a bunch of cases?
They're all out of the same incident, Judge, and she definitely has